Thank you. Welcome to the Licensing and Gambling Acts Casework Subcommittee on Monday, the 12th of January, 6 p.m. In Oxford Town Hall. First of all, just to confirm an election of chair for the subcommittee. Any proposals?
Could I propose Councillor Miles?
Thank you. I will therefore chair the meeting. Thank you. Any apologies for absence? I don't think we have any. No substitutions. Any declarations of interest? No. Just to mention that the procedures for the hearing are attached in your bundles. I think you're all aware of that. And then we'll move on to item number 5, which is the application to review a premise licence for Thirst, which is 7 to 8 Park End Street, Oxford. And we are being asked to determine the review of this licence. So if we could invite the applicant, which is Trading Standards, in, who has requested this review. Thank you. Okay, thank you very much. Good evening, everyone. Welcome to tonight's review of Thirst's licence. I'm Councillor Catherine Miles, and I'm going to be chairing this subcommittee tonight. And we'll just do a round of introductions and start with the others on the panel and go around the room.
Councillor Simon Martina, I'm on the committee tonight.
I'm Councillor Louise Upton. I'm another member of the committee.
Tesfar Askar, I'm the legal advisor to the committee.
Cecilia Robinson, observing legal advisor today.
Hannah Carmody Brown, I'm a clerk for this meeting.
Yeah, and Richard Masters, Senior Licensing Compliance Officer for Oxford City Council.
And can we have an introduction from yourselves as well, please? Briefly, so. Yeah.
I'm Craig Bayliss. I'm representing the Thirst Bar tonight.
And I'm Rob Ofer.
Thank you very much, everybody, and welcome to the meeting. Just to explain the process and just to remind everyone that this is being live streamed, so it is all going to be publicly available, the information that is shared tonight. So you might choose your words if you are aware of that. So the subcommittee have read the papers, so when we go through each of the items tonight, you don't have to repeat everything in extensive detail. The hearing is going to take form of a discussion, and each party is going to be asked to make their statements, and members of the committee and the licensing authority. So Richard will ask questions to clarify any of the evidence that's given or any of the issues that are raised. We expect the first part to last around 20 minutes or so, and each party will then have an opportunity to sum up, and thereafter then everybody apart from the panel and the legal advisor and clerk will retire, and we will then deliberate and make our decision before then you being invited back into the room. So any questions on any of that at this stage? All good. Okay, then what we'll do first of all, we'll turn to the licensing officer, Richard, who will present the case. So thank you, Richard.
Thank you, Chair. This licensing subcommittee hearing is convened to determine an application submitted by Oxfordshire County Council Trading Standards for review of the premises licence in respect of Thirst 7 to 8 Park End Street in Oxford. The view of the premises licence has been brought due to evidence that the licensed premises has been used to store and supply illegal tobacco products on 3 separate occasions in breach of the licensing objective of preventing crime and disorder. In addition, the failure to display the statutory tobacco warning notice and the advertising or promotion of shisha via social media has been identified during the course of the investigation in breach of the licensing objective of protection of children from harm. Although a revocation should be strongly considered, trading standards are recommending that a period of suspension and the addition of relevant conditions to the premises licence would act as a necessary deterrent to promote the crime and disorder licensing objective and to protect the wider community. A copy of the application and annexes of evidence can be found at Appendix 1, along with the recommended conditions proposed by trading standards. A copy of the current premises licence can be found at Appendix 2. Valid representations supporting the review of the premises licence have been received from 2 of the responsible authorities, Thames Valley Police and Public Health. Copies of these representations are attached to Appendix 3 and Appendix 4 respectively. Upon receipt of the review application, the premises licence holder submitted a mitigation statement accepting full responsibility and offering measures to ensure the offences are not repeated, including a period of temporary closure for 2 weeks commencing the 5th of January 2026. A copy of this statement is attached to Appendix 5. The subcommittee and all other parties at this hearing will note that a map detailing the applicant's premises and the surrounding areas is attached to Appendix 6. The subcommittee is reminded of its responsibilities under the Crime and Disorder Act and the Human Rights Act. Any decision taken by the subcommittee must be necessary and proportionate to the objectives being pursued. Members are reminded that whenever they make a decision under Licensing Act 2003, they have a duty to act with a view to promoting the licensing objectives. In making its decision, the subcommittee must also have regard to the Home Office statutory guidance issued under Section 182 of the Licensing Act 2003 and the Council's own statement of licensing policy. Details of these can be found within the body of the report. But the subcommittee must take such of the following steps as it considers appropriate for the promotion of the licensing objectives. They can either modify the conditions of the licence, exclude licensing activity from the scope of the licence, remove the designated premises supervisor, suspend the licence for a period not exceeding 3 months, or to revoke the licence. And for this purpose, the conditions of the licence are modified if any of them is altered or omitted, or any new condition is added. Members should note the applicant or persons making representations have the right to appeal against the decision made by the subcommittee. Thank you, Chair.
Thank you very much. Do we have any questions for licensing in the panel?
Not at this point.
No. Okay. Any questions from legal? No. Any questions for yourself or anyone else? No. Okay. All right. Then what we'll do then in light of that, we'll come to the applicant and go to trading standards. If you can present your case, please. Thank you.
Good evening, Chair, members. Thank you for your time this evening and for reading through the substantial number of documents within the submission. This review is being brought because evidence indicates the licensed premises has been used to supply and store illegal water pipe tobacco, and that the premises license holder has unlawfully advertised or promoted tobacco products in breach of the licensing objectives. These are serious matters that go to the heart of crime prevention and public health. What you've read in the application constitutes alleged criminal offences. Case files have already been submitted to the legal department. However, and this is an important point, this review is not about determining guilt or innocence. It's about ensuring the promotion of the licensing objectives, particularly the prevention of crime and the protection of children from harm. Licensing objectives exist for a reason. They're not abstract principles. They're practical safeguards designed to protect communities. When premises are associated with criminal activity, the law expects decisive action. And this is not optional, it's a statutory duty. But before we turn to the evidence, let me explain what water pipe tobacco is and why it matters. Water pipe tobacco smoking, commonly known as shisha or hookah, is a traditional practice in the Middle East and South Asia. In recent years, it's become increasingly popular in the UK, particularly among young people and students. It's often marketed as a social activity, which adds to its appeal. If I could ask you to turn to page 147 of your bundle. You'll see an example of a water pipe. So tobacco mixed with flavoured molasses is packed into the bowl at the top of the pipe. It's then heated with burning charcoal, and the smoke then passes through water before being inhaled by the user by sucking on the attached hose. Now, here is the critical point. A typical 1 hour session can expose a smoker to the same volume of smoke as over 100 cigarettes. That's correct, 100 cigarettes. This is why water pipe smoking is recognised as a significant public health concern. There are persistent myths that water filtration makes it safer than cigarette smoking, or that the fruity flavours somehow reduce the harm. Both are false. The toxins are not filtered out by water. The fruity flavours simply disguise the harshness of the tobacco, making it attractive to non-smokers and young people. And this is why UK law requires mandatory clear health warnings on unit packs and water pipes, and also strictly prohibits any reference to taste or smell. Like other forms of tobacco, shisha is also subject to duty. Smuggled versions evade tax. They lack health warnings and they're sold cheaply. They're sold cheaply because the tax has been evaded. This is not a minor technical breach. It's criminality that undermines legitimate businesses and public health. The Secretary of State's guidance is unequivocal. It says, quote, "There is certain criminal activity that may arise in connection with licensed premises which should be treated particularly seriously. The list includes the use of the licensed premises for the sale or storage of smuggled tobacco." It goes on to say, revocation of the licence, even in the first instance, should be seriously considered. The guidance exists for a reason. Illegal tobacco is not just a regulatory issue, it's a criminal offence with wider implications: tax evasion, health risks, and unfair competition. With that context established, let me take you through the chronology of events. On the 1st of August 2024, Trainee Trading Standards Officer Davidson visited Thirst with a colleague to update business records. They were met by resistance from the assistant manager, who pressed them to return on another date. They were told that no water pipe tobacco was kept there or sold, and that the water pipes were only hired out, with customers providing their own tobacco. It was noted at that time that no statutory tobacco warning signage was displayed. Trainee Officer Davidson made contemporaneous notes of this discussion, which she later used to produce a witness statement, which is in your bundle at page 30. If I can ask you to turn to pages 34 to 35. She issued a guidance sheet to the assistant manager. The guidance sheet is a brief summary of the law. You'll see it contains advice on the health labelling required, the prohibition on advertising, the requirement for the statutory warning sign, and the explicit warning that licensed premises could face suspension or even revocation if the law was broken. She also issued an inspection and action report form, which you can see on page 36, and which was signed for. It remains unclear what the assistant manager did with the guidance sheet, but had anyone ensured the advice was implemented, put simply, we would not be sitting here today. On the 16th of March last year, officers conducted a formal inspection of the premises. Arriving at the stated opening time of 9 p.m, they found the door to the premises open and staff behind the bar. The person spoken to, who it later emerged was a duty manager, inexplicably said he was just a bartender and refused to sign the notice issued by officers before an inspection commences. Instead, he rang the assistant manager for advice. The assistant manager told officers that the premises did not open till 10 p.m, and so they must leave and return then. This was not true. It was explained to him that the door was wide open and officers had walked into the premises. He said the door was only open as it was a hot night. Chair, it was not a hot night on the 16th of March. Officers were then told that the shisha storage area was locked and that the person with the key would not arrive until 10 p.m. Upon checking, officers discovered the storage area was in fact unlocked, and contained within it were 10 unit packs of water pipe tobacco with a gross weight of 8 kilograms. Again, the statutory tobacco warning signage was not displayed. If I can ask you to turn to pages 44 through to 55. These show examples of the seized unit packs. All of them were illegal. This was because they did not contain the statutory written and pictorial health warnings required. They make prohibited references to tastes or smells, and it was clear just from the labelling alone that the items had been smuggled. The duty value of these products was just under £1,500. This, we say, is evidence of the licensed premises being used for the storage of the smuggled tobacco. An inspection and action report form was issued, but the duty manager again refused to sign it. Further investigation established that the shisha business was operated by a third party, Mr. Shridi, who paid just under £8,000 per annum to Spirit Bar Limited to operate from the premises. Mr. Shridi had run the business from Thirst since around 2009. He had left the UK due to a family bereavement and did not return until July, which delayed the investigation. In the meantime, Robert Offer, director of Spirit Bar Limited, was interviewed under caution on behalf of the company. Chair, you would have already read the summary of the interview in my submission, so I will not repeat it again, but I will make 2 points. Mr. Offer was frank, straightforward, and fully engaged in the process. And 2, the company appeared to have had little or no understanding of either the legal expectations of them as a premises licence holder in relation to the shisha operation, or the previous history and advice given to them regarding shisha. It was the company's understanding that water pipe tobacco was sold and supplied for customers to consume, in contradiction to what officers were told in the August visit. Mr. Shridi was eventually also interviewed under caution. He claimed that 3 of the seized unit packs had been left by a customer. He could not account for the other unit packs. Again, I have laid out the summary of the main points of the interview in my submission, but suffice to say, Mr. Shridi's account was unclear, lacking in detail, and contradicted the account of Mr. Offer. Further questions were sent via correspondence in an attempt to clarify the situation to Mr. Shridi, and a response was not received. If I can ask you now to turn to page 57 through to pages 77. These show numerous social media posts made by the Thirst accounts. The effect of these posts was to promote shisha. Photos of groups around water pipes, hashtags such as shisha, hookah, and shisha garden, and signage stating shisha £15. No health warnings are visible on any of the water pipes. These posts were public, accessible to under 18s, and contrary to the objective of protecting children from harm. Imagine a young person scrolling through Instagram and Facebook, seeing these posts. They normalise and glamorise a practice that carries serious health risks and is illegal when promoted. This is not a trivial breach. It's a direct contravention of the Tobacco Advertising and Promotion Act, a law which has been in place for well over 20 years. The first Facebook account has 10,000 followers, and the Instagram account has 2,320 followers. Disappointingly, when I checked on Friday, all these posts remain online and have not been removed, despite them being brought to the company's attention in September. The posts give no support to Mr. Shridi and the assistant manager's claims that customers brought their own shisha into the premises and simply paid £15 to hire the water pipes. There's no mention of this in any of the posts. Given what was seized and the lack of credible explanation from Mr. Shridi for why 9 kilograms of smuggled tobacco was otherwise on the premises, on the balance of probabilities, it's reasonable to conclude that the company explanation is the correct one and that the shisha operation was selling tobacco directly to patrons. But it is damning that despite a face-to-face interview with the company and a follow-up questionnaire, a face-to-face interview with the shisha operator and a follow-up questionnaire, and a face-to-face interview with the assistant manager, we still cannot say with confidence what the system of supply actually was within the premises. If Mr. Shridi's account is true, and customers were bringing their own tobacco into the premises to smoke via hired water pipes, what system was in place to ensure that smuggled or counterfeit tobacco was not being brought into the premises? Or what system was in place to ensure that any such tobacco had not been pre-mixed with cannabis? Or worse, laced with a date rape drug like GHB? Chair, as you have read, this is not an isolated incident. In 2019 and 2020, joint visits resulted in seizures of 9 kilograms and 7.5 kilograms of smuggled water pipe tobacco. If I can ask you to turn to page 100. You will see that comprehensive written advice was provided in 2019, including regarding the prohibition on social media advertising and water pipe labelling. This was followed up by face-to-face meetings with the company's operations manager and the shisha operator to explain the law, and signed acknowledgements were obtained from both parties, which are in your bundle at page 108 and 109. Yet, the same breaches have occurred again in 2025. As you've already heard, the statutory guidance regards such criminal activity as serious. Case law confirms deterrence is an appropriate consideration. Illegal tobacco gives premises an unfair commercial advantage and poses significant public health risks. Indeed, public health has recommended revocation of the licence in this instance. Chair, this is not just about compliance, it's about protecting the public. Smuggled tobacco is not subject to the same quality controls, and it is sold at prices well below the legally compliant versions. Social media posts glamorising shisha smoking send a dangerous message to young people. They normalise a practice that carries serious health risks and is illegal when promoted. Chair, revocation is clearly justified under guidance and precedent. However, as you've heard, Trading Standards does not recommend revocation on this occasion. We do recognise the proactive steps now taken. The shisha operation has closed permanently. The company has voluntarily closed for 1 week already and proposes to do so for a further week. We are also told that management changes have been made. We propose additional conditions to promote the crime prevention objective and protect the wider community as set out in the written submission. And we are told from the respondent that they accept those conditions, which is appreciated. Any further sanction is, of course, for your consideration. Chair, that concludes the representation, unless I can assist you further.
Thank you very much. We appreciate the comprehensive pack and also the comprehensive explanation. Very helpful. Do we have any questions from the subcommittee at this stage?
Yeah, the social media post that you referred to, is it right in saying that they are posts made by Thirst, not the Shisha Company? And secondly, you drew attention of a social media post to the management of Thirst some time ago. And thirdly, no action has been taken about them.
Yes, the social media posts were made from the Thirst accounts, not from the Shisha operator's account. They were brought to attention of the company in writing initially in September, and then obviously again by the licence review process. Sorry, I think you asked the third.
You confirm no action has been taken to remove those social media posts?
Yeah, I checked on Friday and unfortunately they're all still there, haven't been removed.
Okay.
Sorry. Could you just tell me again, you mentioned that there were face-to-face meetings in 2019, 2020. Can you just tell me again, like, who were those with?
The face-to-face meeting was with the operations manager of a Spirit Bar Limited and Mr. Shridi.
Operations manager.
Any further questions? I think I have a question. Bear with me. Yeah. So my understanding from the bundle was that there was an informal arrangement with Mr. Shridi in terms of providing that service. Did you receive any clarification in the interaction about why this was not documented? And also, was Mr. Shridi operating this as a formally registered company, from your understanding? Thank you.
Yes, from our understanding, Chair, through the interview, this was an informal arrangement that grew organically from when it first started. It became a bit more formalised in the last couple of years due to increases in the insurance premium, and that came to the arrangement that Mr. Shridi would start paying just under £8,000 a year, whereas before there wasn't any formal arrangement. There are different, so Mr. Shridi did not operate as a limited company and was rather evasive at interview about exactly how much turnover was. And in fact, what Mr. Shridi says was his turnover would mean once you paid the £8,000, you'd make a significant loss and be working for free. So unfortunately, no, there was a questionnaire sent to Mr. Shridi to try and clarify this, and no response was received despite being chased.
And just to follow up, and just to clarify, Mr. Shridi, my understanding is Mr. Shridi has not clarified where he was procuring the tobacco. Is that correct? There was some reference to the Cali Road, but there's no further information beyond that in terms of the due diligence of where it was being procured from.
So, Chair, and Mr. Shridi was denying that his business was selling or supplying tobacco. He still claims that customers were bringing tobacco into the premises, and he just hired them the water pipe. But he hasn't been able to account for why there was 9 kilograms of water pipe tobacco on the premises.
You said that these packs could have contained illegal drugs, date rape or cannabis or whatever. Have you checked whether they did or didn't? Can you confirm that they didn't, or is that under police investigation still, or what's the situation?
No, Chair, that isn't something that we have investigated. I think more was the point I was making was if Mr. Shridi was correct, what system did the premises licence holder have in place to make sure those things weren't being done? We have no evidence that those things were being done, but if Mr. Shridi's explanation of how his business was operating clearly could have been open to either of those things happening unless there was a system in place. But there was not a formal system in place because the premises licence holder says that wasn't the system. The system was that Mr. Sreedy sold the tobacco with the water pipe, which was the system in 2019 and 2020.
The lack of structure and lack of system means that any drugs could have been sold on that premises without the management knowing it. Is that right?
If tobacco was being brought into the premises by consumers to use in the water pipe, unless there was a system in place to checking that they weren't other contraband, then yeah, who knows? But Trading Stand's opinion is Mr. Offer's explanation is likely to be the true one, because you'll note the quantity seized in 2025 is a very similar quantity to that seized in 2019 and 2020 when the system wasn't this higher system. So we don't know. Mr. Sreedy isn't here to explain the contradiction, and we have tried our best to try and establish what the system was, but we can't say with any certainty.
Tell me, this might be something for us to discuss later rather than for me to ask now, but you're not recommending a suspension. Have you? Revocation, sorry. But you're just, yes, so you're just recommending a short suspension. Do you think that's going to be enough of a deterrent? I guess the answer to that's going to be yes, but I'm just thinking, do you have any past cases where you've tried that and have been happy that that was enough of a sanction?
Chair, we're not, we haven't recommended revocation because this is an on-licence premises. So if this was an off-licence premises and we have sat before you with an off-licence premises in the same street, and we did recommend revocation because that business can still operate without an alcohol licence. If this business doesn't have an alcohol licence, it won't exist. And I think all responsible authorities want legitimate business to thrive. And so we're encouraged with what we've heard from Mr. Offer and what you all have heard in their submission. And we believe that if followed, then there won't be a repeat because there will be no shisha ever allowed in that premises again, as per the condition that we have suggested. This isn't about the nightclub business. This is about the shisha operation. And if that side of the operation is going to cease, then we believe that it's proportionate not to seek revocation.
But if we did revoke the licence, the business could be sold to somebody else who could then apply for a licence and somebody that managed it in a more responsible way, yeah?
That's correct.
This fact that the current managers or operators of Thirst claim to be ignorant of the regulations of around tobacco advertising, etc. Is that common amongst people who are operating this kind of business to really not know that?
It's difficult for me to comment because I can only speak on behalf of the businesses that I've interacted with. I would say that the shisha operators have been a problem across the country in terms of non-compliance. And I put an extract in your pack from the Local Government Association report arguing for licensing of shisha operators because of that issue. So I think there is some lack of understanding of the law and perhaps historically a lack of enforcement of the law as well. That isn't the case. That isn't the case now. We have, in 2019, this was new work for us as a local authority, and that's why we adopted the approach we did, which was to engage with businesses and provide detailed and hopefully helpful written and verbal advice. But we can't keep on repeating that advice. At some point, there is a duty to take enforcement action, which is why we're here today now.
how frequently does Trading Standards typically visit such an establishment, you know, under these circumstances? And would that change based on any of this, any decision that is taken here today if they were to continue to operate? Thank you.
So 2019 was a regional Southeast Trading Standards project where all authorities in the Southeast area were agreed to do a project where we would visit any shisha bar or cafe operators. This work hadn't been done before in Oxfordshire. And you'll see in the LJ report that our work was actually used as a case study because we found such widespread non-compliance. So we felt it was fair then to engage with the operators and provide advice. We then did the follow-up work in February 2020 and unfortunately found more non-compliance. Now, had the global pandemic not then hit and the public interest wasn't to take enforcement action at that time, we probably would be had our review earlier. Then there hasn't been any further visits until the 2024 visits. Those business update visits were to try and see in those intervening 4 years, did the businesses still exist? Were they still serving shisha? And then from the information gained, we then did the enforcement work in 2025. Thirst were not the only business inspected, and they were not the only shisha business seized from. So in terms of, to answer your question of how often we would revisit, it's really down to prioritisation from the Trading Standards leadership team. As you can imagine, there are literally thousands of businesses in the whole of the county in terms of tobacco. And we are intelligence led because there's not enough officers to do everything that we would hope to do. So I couldn't say exactly when, but we would look to, if we receive complaints and intelligence, we would look to revisit any premises.
Assuming there are trade organisations that cover nightclubs, things like that, are you aware of any that might have informed their members about this sort of problem? You say it's a widespread problem. So is it something that the trade is discussing with its members, the potential risks of these selling shisha pipes?
You're absolutely right. There are trade associations and organisations with regard to licensed premises, but of course the vast majority of licensed premises don't sell shisha. So no, I don't think that. I think it probably is something that slips between the cracks of a lot of areas, really, both from the trade and possibly from regulation as well. As I say, it was only in 2019 that it really something I had first learnt about, and Trading Standards started regulating. We have, in the meantime, there are a lot less shisha operators in Oxfordshire now than there were in 2019, 2020, possibly due to the regulation, because actually it's very difficult to make a legally operating shisha business because the cost of genuine shisha is really expensive. You couldn't run the business at the price Mr. Shriti was charging if you were buying legitimate shisha. The maths just won't work.
A question around the payment. You referred to this 8,000 being paid Mr. Shriti to Thirst. In terms of the customers making payments for, this ambiguous either the hire or also the tobacco, depending on which version you interpret, how did that transaction take place? Was that cash or card, and how was there a track of that? Thank you.
So customers would pay the shisha operator directly, either via cash or via a card machine. Customers wouldn't know that they were dealing with a different business, but the takings were separated. I did try very hard to pin Mr. Shriti down to figures, but as I said in my summary, he was somewhat evasive and described it as not a real business. He said no one paid £15. Everyone would barter. We would often give it away for free. His description of the business didn't really wasn't consistent with someone who's been doing this since 2009, because the way he said it was almost like a voluntary charity or something. Whereas Mr. Offer has provided clear invoices of the payments made with regard to the insurance. So we know that, I think we can say with confidence, Mr. Shreely was paying just under £8,000 a year to be there. And so I think it's reasonable to conclude that he's going, because he had staff as well, that he's going to have turnover more than that a year to make it worthwhile. Otherwise, he's working for a loss.
And just a clarification, there was some reference to the staff working for Mr. Shreely who were not able to communicate effectively with officers. Now, that could be for various reasons, but was there any evidence that there is any due diligence done on whether these individuals are actually allowed to be working?
Yes, it's absolutely a good point. I don't think Mr. Shreely was regarded what he was doing as running a formal business. He didn't even know the name of the person who was running the shisha operation in August. So the person who was there, when I asked him who it was, he didn't know that name. So it was very haphazard, really.
And to clarify, this is in theory someone that's operating the business on his behalf.
Absolutely, yes.
Okay, that raises some significant questions. Are these questions being dealt then with by other authorities, presumably outside the trading standards? Yeah.
Yes, I mean, all the intelligence that we receive in the course of our duties is disseminated to any other interested body, and in this case, yes.
Any other questions on this? No. Okay. No. Okay. All right. We don't have any of the responsible authorities other than yourselves as the applicant here. So I think at that point, we're concluding our questions for yourselves as trading standards. I think now we then go to I think we can come to yourselves. And if you would like to, if the representatives of Thirst would like to make any statement.
It's very violent with the operator. I'll take this quite short because I'm sure you have lots of questions. So thanks for doing the bare bones with where we got.
Oh, could you use your microphone as well?
I'm sorry, yes, in terms of how we sit with this. As Russell, the officer's already indicated to you, you're not a court of law. You're not here to establish guilt or innocence or decide whether or not offences have been committed. Your job tonight in relation to the review is to deal with the issue of a failure to promote the licensing objectives. And as yet, no prosecutions have been brought. There may never be prosecutions brought. So guilt or innocence isn't an issue for you. And breaches of the law are not an issue for you tonight. It's simply a question of whether or not the activities, which we freely admit took place, did not promote the licensing objectives sufficiently well. Before I get into the main meat of what I wanted to say, Councillor Ottino, one of the questions from Councillor Ottino was a suggestion that other substances might have been made available. There's no evidence of that at all. And you must, at a review hearing, it's most important that you proceed on an evidential basis rather than supposition of what might or might not have happened. Mr. Shreely was running this operation as a third party. It was nothing to do with Thirst at all. The only money that we took from Mr. Shreely was £8,000 a year, which covered the increase in insurance costs. Mr. Ofer and Spirit Bar Limited made no money out of this. This was simply a promotional activity where he was given space to operate at the rear of the premises. He didn't use any Thirst employees. He didn't use any Spirit Bar employees. All his employees were his own. He carried on his own operation in our premises, and it was simply a promotional effect for our premises. When Mr. Ofer came to me and told me what had happened, we've had a discussion about it. He accepts he was incredibly naive in allowing this to take place, especially with no knowledge of the relevant laws in terms of tobacco supply or health and the Health Act. He is disappointed that his lower management didn't report any of these visits to him. The visits that you've heard about from Russell, which took place in 2019 and 2020, were never reported to Mr. Ofer as a director. He didn't know anything about them until he came to the interview under caution in 2025. It's as a result of that all the management team who were involved previously have gone. He's got a completely new management team in there now. The other point that I wanted to emphasise to Mr. Ofer when he came to me first of all was that he had to show a substantial element of contrition for allowing this to happen in any format in his premises. And I advised him, having seen what was suggested by trading standards in terms of a period of suspension of the licence, I suggested to Rob that he should voluntarily close the premises for at least 2 weeks, which he's done. We're halfway through that process at the moment. I've asked him to produce some figures for me, comparable figures, trading figures from last year. Trading figures from last year indicate that if he'd stayed open for these 2 weeks, he'd have taken £39,200. So he's lost at least £39,000 in trading terms, closing for these 2 weeks. In addition to that, he still has to pay his staff. In addition to that, he still has to pay rent. So it's a significant hit in the pocket closing for 2 weeks, but it's something that he accepts he must do, and it's something that he wants to do to demonstrate contrition and to demonstrate that he got this wrong. He was naive, it was stupid, and it shouldn't have happened. So the total losses over these 2 weeks last year were 39,225. As Russell said, we've seen the conditions which are suggested. We're entirely happy to accept those conditions on the licence. There is no likelihood that Shisha will ever set its foot across these premises again. It was a mistake. It was a stupid mistake, and it will not happen again. Chair, I think that's all I need to say at this stage, but happy to take questions.
Yeah, thank you very much. No, we appreciate that, and also appreciate and note the conditions that you have put forward that you're willing to accept. I'm sure that there are some questions from the panel, so just like to, yeah.
Thank you. Mr. Duff, how often do you talk to your managers normally?
Quite a lot now. Previously, I did take a bit of a backseat. I became a parent at a very old age and spent majority of my time at home with my young children, bringing them up, instead of selling the business. In hindsight, perhaps I should have just sold the business. But I have a business partner who lives in London, and he had a heart attack, so he was unable to come to Oxford so often. And so, in a way, I was left running quite a few businesses and being at home quite a lot. It's not a great excuse, but it's a fact that I allowed the managers to have a certain amount of autonomy. And because of that, they didn't tell me things that they should have done. And it's come back to this situation I'm in now, which I've now changed because I've changed the 2 managers. And my kids are older and I'm more involved in my business. And I've learned from this, and through meeting Russell and talking to Craig, my solicitor, and I've been fully cooperative and explained myself. It was very much encouraged by my managers who felt that it was good for the business. Regarding the social media, I'll admit I'm 58 years old. I don't use social media. I apologise. I will have it removed tomorrow. It was made very aware to me. Again, I don't use social media, so it's my fault. And as Craig said, we have closed the business at great expense through the advice of Craig and Craig's conversation with trading standards, that I need to prove that I accept responsibility, even though I feel it was a third party involved in my business. So, yeah.
Chair, sorry, one other point I should have made in my initial speech. The DPS for the premises, currently on the premises licence, is Mr. Thompson, who is Rob's business partner who lives in London. I'm suggesting that we will change the DPS so that it becomes Rob. He will then obviously, if it becomes the DPS, he's local and he establishes a much more tighter element of control over the premises instead of it being a remote person.
Okay. To clarify on that, so Mr. Oakford, you based here in Oxfordshire?
Yes,
Yeah.
yes, I live locally.
Okay.
I live in, yes, I do.
Okay, thank you. And do you run any other businesses in the city, or is this the?
Yes,
Yes, you do.
we do.
Okay,
Yes,
great.
we have 2 others. Yes.
I think we had a question here.
Yeah. I mean, if you're saying you've been naive, how is that supposed to inspire us with confidence that you're going to uphold the licensing objectives if your management?
I was naive in allowing a third party to operate within my business and not have full control of that. Now I understand through the circumstances that have occurred, so that can't happen again. Because in terms of running the business or the bar, since I opened it in November 1999. So we've been there 25 years. This is the first time that I've been brought upon a committee, a subcommittee, in relation to any of my businesses, not related to the alcohol of my core part of the business, but related to a third party who has, in my opinion, clearly lied, because what I was told and what I've said is very different to what he has said, to what I know that is true. So at no point have I attempted to cover anything up. So perhaps naive is the wrong word. Perhaps the better word is I won't be so trusting in allowing any third party ever to operate within any of my businesses.
So can you confirm that there's nobody else working in your bar in any manner, like such as a cleaner, or whether that is not directly employed by you, that might be employed by a company with some sort of illegal practice, maybe not paying their staff correct wages, or maybe not having the right to work in the country?
No, we don't. We have a scope security as a contractor. We have cleaning companies who are legitimate cleaning companies who are contracted in, but the rest of the staff and managers are directly employed by Spirit Bar Limited.
Yeah, just in terms of training of the staff, obviously you sort of mentioned you've changed the management. What's your approach going to be to training up the new staff on not only all aspects of their responsibilities? under the
Already been done,
Licensing
Chair.
Act?
It's already been done.
Could you clarify what training has been given and how you will be redoing that training on a regular basis if there's time?
Of course, we use a company who come in, who is a consultant who deals with all our contracts for our staff, and he helps us in relation to all of the compliance and legal obligations that our bar staff or managers have in terms of running a licensed premises. So you could visit tonight and see and come in and ask for a register to see that those staff had been trained and signed and dated and what they've done.
Yeah, you've referred to this as a promotional activity. I mean, that means you gain financially from it. You put on promotions because it brings business and money to your business.
Just to clarify the question.
Yeah. Surely at some point you personally made a decision that you wanted to continue with that activity because it was bringing your business money, and therefore you have some responsibility over what was going on.
To clarify, can you clarify?
Do you accept that you have, as you were making money out of the promotion, that you had a responsibility to investigate what was going on or to have an understanding of what was going on?
I didn't know there was anything to investigate because I hadn't been told that there was an investigation.
But are you not in charge of your business?
It wasn't, Chair, with respect, it wasn't his business. It was a third party's business. He was just given space on the premises in order to conduct his own business. We knew nothing about what he was doing. We had no involvement in his business. We didn't tell him what to do. We didn't manage any of his staff. It was all out with our control.
Thank you. Can we just keep our questions to...
So is a
to
promotion
questions,
part of your
please?
business? Because it does, my understanding of a promotion is it brings people into your business who buy more drinks or whatever, pay the entrance fee maybe.
I saw it
As
more,
a promotion.
I saw it more
were you making
as a service, as an additional service. So the way that I was encouraged to have shisha was that the manager said, young people like to do shisha and have a drink together, and we sell the drink and someone else sells the shisha. So it's that's how I saw it.
Just a clarification around the shisha provider and your relationship. I know that it was an informal arrangement based on the information that has been shared. Why did you make the decision to keep it informal, or was it a formal decision to keep it informal, or was it?
It was never formalised in the sense that the managers introduced me to him and said, "This is what he would like to do, and we think it's good for the business." And I said, "Okay, then, well, that sounds like a good idea." It was only later on that one of our underwriters through our insurance broker said, in a form, what do you do in your premises? And one of the questions was, do you sell shisha? And I ticked yes. That they came back and said, well, the underwriters see that as a liability, and that liability will cost you £8,000 a year. So I said to the manager, well, I don't want to pay the £8,000, and it was volunteered by Mr. Shriddy to pay that. So that's where that sum came from, and I gave that evidence to Russell at Trading Standards.
Are there any final questions from the panel? Yes, any final questions? No. Do we have any from legal? Do we have any from yourself? Okay, thank you. I think that concludes the questions that we've got for yourselves. I think at this point, in case there are no final questions, then it's procedurally, there's like a sum up from the applicant first of all, which is Trading Standards. So it's over to you for a sum up, please, from the Trading Standards perspective, please.
Thank you, Chair. I'm not going to add too much because you've already heard extensively from us. There has been previous seizures from this premises and previous advice given. And so it is disappointing that we're here today, but we are reassured from what we've heard that we won't be here again in the future. That's why we are not recommending a revocation.
Thank you. Okay, we don't have the responsible authorities, interested parties. So to yourself, licensing officer, yeah, Richard.
As a committee, so the committee must take such of the following steps as it considers appropriate for the promotion of the licence objectives. Modify conditions of the licence. Obviously, we've had some conditions offered by Trading Standards that have been accepted. To exclude licensed activity from the scope of the licence, to remove the designated premises supervisor, and again, that has been offered. To suspend the licence for a period not exceeding 3 months, or to revoke the licence. Thank you, Chair.
And I think at that point, any final summing up from yourself?
Chair, only a couple of points just to re-emphasise really the fact that we're not a court of law. We're not trying to establish guilt or innocence. This is all about the licensing objectives and the failure to promote them, which we readily accept. We got wrong. It was a third party. It was nothing to do with our operation. We got it badly wrong. We should have made more investigation, and we didn't. But we've taken the voluntary tack to close for 2 weeks, to lose at least the equivalent of what we lost last year, which was £39,000, plus paying rent, plus paying the staff while we're closed. It's a significant hit in the pocket for Mr. Ofer, and it's something that he doesn't take lightly, but he accepted my advice to do it because it was the right thing to do, to demonstrate to you contrition and future compliance.
At this point then, we say thank you for your time. We're going to ask you to leave the room and we will then deliberate. So we'll invite you in when we've made our decision. So thank you. Thank you very much, everybody, and thank you very much for the time that you've taken waiting for us. So we were really concerned about what has been presented to us this evening, because serious criminal activity has taken place on your watch, and your business has failed to uphold the licensing objectives to safeguard and protect communities, and specifically the licensing objectives of prevention of crime and disorder and protection of children from harm. And so your business, as a result of that, has profited from this illegal and harmful activity by a third party. The social media posts, which we've heard about today, glamorise and promote a harmful activity that none of us would want our friends or relatives or children to be partaking in. And this goes against the Tobacco Advertising and Promotion Act of 2022. It also goes against the policy of a smoke-free Oxfordshire, which is something that this council has also endorsed. The seizure of such tobacco in a retail premise would result in a revocation. And we've heard this from trading standards. This kind of tobacco is a significant health risk and has a huge cost to our community here in Oxford and our country, but our NHS, and also undermines legitimate businesses in our city. So this is the context. Nevertheless, we recognise we're not here to attribute guilt by you as an individual or for your business. That's for another venue, and we accept that you're sorry and that you're serious about not allowing this to happen again. And you've made dramatic changes as well. And so for this reason, our decision tonight is that we do formally want on paper it to be noted that your licence has been suspended until the 23rd of January at 4 p.m. And then that the conditions of the operating schedule from thereafter would be modified to be effective from the 23rd of January. And these would include the following conditions, which you've already accepted, but just because we're on live stream, I'll read them out so it's very clear to everybody. So no tobacco or herbal smoking products to be stored, sold or supplied in the course of a business. No water pipes to be available for use on the premise, whether by payment or for a fee or not. And then an A3 illegal tobacco keep it out poster, including the illegal tobacco hotline reporting number, would be shall be displayed prominently at the entrance and outside of the licensed premise at all times, and this will be supplied by trading standards. And then in terms of training, the conditions will be that all staff working at the premises in a managerial or supervisory capacity, whether paid or unpaid, shall receive training on the role of the responsible authorities. Training to include expectations from the company on how members of staff are to conduct themselves and communication of all visits. And with visits, we think that the word compliance visits should be clearer that the condition refers to compliance visits, and any written materials in accordance with the management structure. And then training to be given on appointment by a managerial or supervisory capacity and repeated on an annual basis, and records of such training to be kept at the premises and made available to any officer of a responsible authority upon request. So in addition to this, because these are the formal conditions which are on your licence, we do have some recommendations. The first is something that you have mentioned. We can't condition it, but we are expecting as an immediate activity, and that is the removal of the illegal social media posts, because they're currently in breach of this act around tobacco advertising. We recommend what you have proposed to us, which is there is a change of the DPS so that the individually is locally resident, and we're assuming it's going to be you. And we also would like to add that we'd like you to share your experiences with trade associations to prevent this happening to other businesses, such as like your own. So we don't know which is the most appropriate one, but we would recommend that you do take a public platform to make those statements. And for the rest, that's for other authorities, but that is our decision tonight. I think you do have, I can say that you do, are you allowed to appeal any of these new conditions that we put upon you? And you have that right to appeal within 21 days. Thank you very much. But
On the day you received the decision.
So thank you very much. And thank you to everybody for your contributions this evening. Thank you. And we